Hi friend, welcome to the Company Law Adjudication and Appeal Series. Today we are discussing Delhi ROC adjudication order in the matter of the Mind Fintech Private Limited. There is a violation of section 89 of the Companies Act. The company name is the Mind Fintech Private Limited and its register office at Delhi, and as per the MCA record for financial year ended 31st March 2023, this record showed that the company is a holding company, so this is not considered as a small company for lesser imposition of the penalty. Let's see the facts of the case. It is observed from the record that company has filed its annual return for the financial year 2022-23, where it is mentioned that the Mind Solution Private Limited is holding 100% share in the subject company. However, it is seen that the company has in total two shareholders. Therefore, the beneficial holder and the registered holder ought to have declared the status of their interest in the shares in terms of section 89 subsection 1 and 89 subsection 2. Further, it was also seen that the company has not filed MGT 6 with this office. Therefore, it is appeared that there is a violation of section 89 subsection 1, subsection 2 and subsection 6 of the Act. In view of the facts, a so-called notice issued by the adjudication officer, and in response to so-called notice, company had submitted a request via email for the extension of the time to file reply in the matter of in this matter. Subsequently, while email dated 23rd October 2023, company was allowed to submit its reply by 30th October 2020. There is a taking extension. A reply in the matter was received on 29th October 2023, which stated that copy of Form MGT 4 dated 27th January 2021, 2 years back, was submitted and signed by Sri Vivek Mishra, and copy of MGT 5 dated 27th January 2021 was submitted by Mind Solution Private Limited and signed by Sri Sandeep Mohindru. And copy of Form MGT 6, that is the return copy attaching Form MGT 4 and MGT 5, is filed on 28 अक्टूबर 2023. मतलब इसका मतलब ये हुआ कि जब उन्होंने सो कॉज नोटिस दिया तो इन्होंने एक्सटेंशन लेने के बाद या जो रिटर्न है MGT 6 वो फाइल किया है यहाँ पे. The company has a wholly owned subsidiary since incorporation and holding 99.99% shares through its authorized representative and one share held by Mr. Vivek Mishra to fulfill the statutory requirement to have a minimum number of two members as required by the Companies Act. In terms of Section 187, the alleged company was of the opinion that Mr. Vivek Mishra holds one share of the company in the capacity of a nominee of this company. Hence, the filing of MGT 6 is not applicable to the alleged company. Most importantly, the delay non-filing is inadvertent and there was no intention of the company to hide or conceal any facts or information. Additionally, we would like to submit that no person or public at large was directly or indirectly affected by non-compliances and no undue benefit was being taken by way of non-filing of MGT 6 by the company. In light of the aforesaid facts circumstances, we humbly request to kindly admit our above response, consider it favorably, and kindly waive off the so-called notice and penalty provision. In view of the above, it is evident from the filing of Form MGT 6, the company has received Form MGT 4 and MGT 5 on 27th January 2021, but Form MGT 6 has been filed on 28 October 2020 with delay of 975 days. Let's see the legal provision as mentioned in the Companies Act, that is under Section 89. Subsection 1 says that where the name of the person is entered in the register of a member of the company as a holder of the share, but who does not hold the beneficial interest, such person shall make a declaration within the prescribed time in prescribed form. It's the MGT 4. And second, subsection 2 says, every person who hold or acquire beneficial interest in share of the company shall make a declaration to the company specifying the nature of his interest, particulars of a person in whose name the shares stand registered in the books of the company, and such other particular as may prescribe, means MGT of 5. If any person fails to file a make a declaration under subsection 1, 2, or subsection 3, he shall be liable to penalty of 50,000, and in case of continuous failure, further penalty of 200 rupees for each day after default during such failure continue. And subsection 6 says that where any declaration under this section is made to the company shall make a note of such declaration in registered concern, and shall file within the 30 days from the receipt of the declaration a return in the in form MGT 6 with the registrar in respect of such declaration with prescribed fees and or additional fee as may prescribed. And if company fails to do so before expiry of a specified time period, the company and every officer of the company who is in default liable to penalty of 1,000 rupees for each day during such failure continues, subject to maximum of 5 lakh rupees in the case of the company and 2 lakh rupees in case of officer who is in default. Here is prescribed form MGT 4 and MGT 5, and company return in the MGT 6. And in education, company was in the opinion that there was no requirement of filing of MGT 6. However, it has produced document to this office to show that registered owner and the beneficial owner had submitted form MGT 4 and MGT 5 respectively. In such a case, the company was duty bound to file form MGT 6 within the stipulated timeline, which was clearly not done by the company. The company, as per its own submission, had received form MGT 4 and MGT 5 on 27th January 2021, and accordingly the company was required to file MGT 6 on before 25th February 2021, that is within the 1 month from the receiving of the declaration. And there is a delay of 975 days because MGT 6 was filed on 28 October 2023 after receiving notice from the education officer. The subject company does not get covered under the purview of the small company, since this is the holding company and not attracting benefit of the section 446B. In exercise of the power, the ROC has imposed penalty here that on the company, that is their delay of 975 days in the multiply by 1,000 per day, that is a total 9,75,000 subject to maximum 5 lakh. So maximum 5 lakh imposed on the company, and on the director there is the 2 officer in default. Here is 2 lakh. This is the maximum penalty imposed on the director of the company, and 2 lakh each. That is total 9 lakh penalty imposed on the company and as well as director officer in default. Name of the party mentioned here is by directed to pay the penalty amount. In case of the party other than company, such amount is required to be paid out of their own fund, and there is the said amount of penalty shall be paid within the 90 days of receipt of this order, and intimate this office with proof of penalty paid. Appeal procedure here is given. If preferring appeal, then file appeal within the 60 days from the date of receipt of this order. Thank you so much for watching this update.